Minister, the Institute for Government has said that the proposed restrictions on jury trial are not necessary to turn around the performance in criminal courts. And I saw you at the back of the room when Cassia Rowland was giving her evidence. She detailed numerous other things that should be done, and to that extent, your proposals on jury trial restrictions are largely irrelevant to the backlog. What's your evidence that the Institute for Government is wrong?
Well, first of all, I've not seen the Institute for Government's paper. I have huge respect for the Institute for Government, but I think what Cassie Rowland said is that in her view, on her evidence, and I've not seen what she's based it on, the savings that would be realised through the legislative reforms amount to 10% savings in terms of hearing time, sitting days. I'm not quite sure which she was referring to. Well, even on her own case, that's not insignificant. But what she did say, her contention is that that is less significant than the savings one can achieve through efficiency and productivity savings.
Correct.
That contradicts the conclusion of the independent review, which I've considered and have to take very seriously, because the conclusion that Sir Brian Leveson, David Ormerod and their team reached is that we are not going to bring down the backlog without structural reform. You need to do the efficiency part too, and you need significant investment in additional sitting days and in other parts of the criminal justice system. But Sir Brian's clear conclusion is that that alone will not achieve the outcome that we all want to see. Where I actually agree with the Institute for Government is that their insights into the declining productivity of our criminal justice system are well observed. It's a function of a system that is broken, that it becomes less productive, it becomes a sort of vicious cycle, if you like. And the sorts of things that she pointed to, investment in the workforce, the amount of time lost because there aren't enough lawyers to prosecute or defend, as she fairly acknowledged, is something the government is doing something about, with the match funding of pupilages, significant investment in legal aid, both for solicitors and barristers, to make a sustainable pipeline, just to give one example. But of course, that takes time, and time is probably the one thing.
Your proposal is going to take time, because the Lord Chancellor has confirmed that these proposals won't have retrospective effect. We've got some parts of the country that are booking trials in 4 years' time. So if you take a year to present your legislation, I think the Lord Chancellor said the autumn of 26, if we imagine it takes a year to get through Parliament, assuming you don't U-turn, which I imagine you will do, but let's assume you don't, this new system won't even start until 2028. So the idea that restricting trial by jury is going to have a meaningful impact on the backlog is simply not true, is it, in this Parliament?
Well, let me answer that in stages. First of all, we are dealing with a acute crisis, which is a systemic challenge, and the government's position is that the only way to address that is from multiple angles that comprise structural reform, the productivity savings of the sort that the IFG outlined, in addition to record investment in sitting days and workforce. It's the interaction of the three things.
Well, that nobody disagrees. It's trial by juries that we're talking about. And my view, and I suspect the view of most people here, is that's just not relevant. And it's not going to take effect until 2028 anyway.
Well, I'll address that point in a moment, if I may, because it's an important one. It is the interaction of the major reforms that are proposed here, the increase in the sentencing power, the removal of the right to elect, the modification and the introduction of a permission stage to appeals, and the existence of the Crown Court bench division. We like as parliamentarians to isolate and hone in on the CCBD, but it's the interaction of how those work, and in addition to the time that can save, which the independent review and our own model will support. It's the behavioural effect that has on participants in the system. One of the things that was mentioned earlier was the declining rate in early guilty pleas. If you know that your case is going to come on quicker within a Crown Court bench division. That of itself, it is possible to anticipate will alter behaviour and therefore bring down the backlog quicker by encouraging early guilty pleas. Obviously, no one should feel guilty if they're not in fact guilty, but we do want those who are guilty to plead at an earlier stage without the need for multiple hearings, which adds to that delay. In terms of when the changes will kick in, you're right that in the context of the crisis, and I don't use that word lightly, that we're in, that we cannot delay in terms of how the measures are brought in. And just to be clear, you make a good point, which is that if we were not, having established these proposals, assuming the bill goes through Parliament, it will be important that the changes are applied to cases where the trial hasn't yet commenced within the Crown Court, but they may already be within the system, if you like. And so that means that the implementation of these measures will take effect sooner than I think your question to me suggested. It's not as if every case in the backlog...
So a case that's been committed for trial at the Crown Court, you will re-look at those cases and push some of them through the Swift Court.
I think that is something we have to look at.
So when the Lord Chancellor said it won't be retrospective, that wasn't a wholly accurate answer.
Well, I think the answer that he was giving was in the context of a case, in the question around the impact on remand hearings, and I think that was the context in which he may have addressed that.
He said the changes wouldn't be retrospective. And now what you're giving me is a slightly different answer, because if someone elects to go to the Crown Court at the moment, it's on the assumption there'll be a trial by jury. What you're saying is it might not be, you might be diverted to the Swift Court.
That's right.
That's what you're saying.
That's right.
Okay, so that I think is fundamentally different to what the Lord Chancellor said a few weeks ago.
That is the position, because that is the mechanism for pursuing the what was needed, which is the urgent implementation of these changes.
Because the Lord Chancellor might well have been confused.
Seek some clarity before you move on, because I wrote down during the last session that our previous witnesses made it very clear that these changes would not apply retrospectively, and therefore they would have absolutely no impact on the backlog and would not start to really make any difference till 2029. I may have missed that being said previously, but I think that was very, very strongly said. So if there is any ambiguity about whether or not these measures are retrospective or not, I think that does need to be resolved. I wonder if it's possible to ask for us to perhaps get a follow-up letter to confirm.
I can certainly provide a follow-up letter, but just to be clear, I don't know that I regard retrospective as quite the right term here. If the trial, no one's suggesting that a trial that has commenced or that has gone past
if
PTPH.
You've been committed to trial in the Crown Court at the moment, you're expecting to have a jury trial. And what you're telling me is once these changes take effect, you will divert those people committed but trial not started into the Swift Court.
Yes. If they meet the eligibility criteria, then that is the case.
Most people would regard that as a retrospective change.
Well, it's a change in relation to the procedure that applies to those cases. They're still getting a Crown Court trial under the new proposals.
All right. Can I just continue?